Okay. Well, good morning. It looks like everyone can hear me, so could I welcome everyone back to day 3 of the inquiry proceedings, which today is a hearing in relation to energy and planning policy. So as per usual, it will take the form of a discussion led by myself, focusing upon the case in hand and running through the agenda issued in advance. I've got a number of questions on each of the topics set out in the agenda, so I'll ask those, but parties will also have the opportunity, either during those questions or at the end of them, to make any comments on the matters raised in the hearing statements. So if there's nothing else, no more preliminary matters, can we just make a start? Yeah.
There's only one matter from me, Mum. Good morning, and that is you'll see Mr. David Bell is on the call, and so I mean we'll all be involved, I suspect, but principally David's going to take the lead. So if you direct questions to him in the first place, and then if there's anything else that we need to get involved in, we will. So he's the new, I think, a new face on the call.
Yeah, thank you. Good morning, Mr. Bell. I should have said.
Good morning, yes, thank you.
Yeah. I'm pretty sure I don't need to run through any of the kind of standard procedures with you in terms of housekeeping and stuff like that. And I'll just say there's no fire drills planned for today. So we'll just carry on. Some of the questions and the policy matters that I've got are maybe not entirely for, or maybe not so intended at Nature Scott. So if there are questions that are not so appropriate, I'm just happy to hear you say that, and I'll take evidence from Mr. Bell if necessary on those topics.
Yes, so, thank you for that, ma'am. I appreciate that you've got a sort of wider remit here than Nature Scott interests, so that there might not be a huge amount of input on some of the points from Nature Scott, but where we can assist, we will do so. And Catherine Harris here from Nature Scott as the Hall's witness.
Morning, Catherine. Thanks for joining us, and thanks for that. Okay, so the first matter, which is under item 2 in the agenda, is the National Planning Framework, NPF4, which is for document CD 009001. Okay, and I was just looking to seek parties' views on the implications for the proposal from National Development Status, and I think I'll put that to both parties. So I'll start with Mr. Bell on that, please.
Thank you. I think in answering it, is on page 6 of NPF4, there's reference to the need to make significant progress towards net zero by 2030. And this is at the bottom of page 6 in NPF4. And it's quite evident from looking at NPF4 that climate change and the nature crisis are the founding principles, if you like, and all policies emanate, if you like, from those overall objectives of dealing with that twin crises. Now, the planning system has had national developments before, but they've been relatively few in number. And so for the very first time, we get an elevation of individual development projects of a generating capacity of over 50 megawatts, or there's other transmission infrastructure within that class of development that is now benefiting from that status in NPF4. So it does have, in my view, implications for consent handling in terms of the weight to be given to those developments, and the benefits that would result from those developments would be of national importance. The role is also important in another respect, and on page 4 of NPF4, it references the delivery of 3 places. We've got sustainable places, livable and productive, and the national development for energy generation falls within sustainable places. So that gives us a focus eventually for the policies that relate to sustainable place. We'll come on to those. But on page 4 of NPF 4, it says 18 national developments support this strategy. That's the National Spatial Strategy. And it says national developments will be a focus for delivery. So I think it's helpful at the start to see how the national developments are aimed at contributing to the delivery of the spatial strategy. To get a bit more detail about what they are, at page 100 of NPF 4, there is reference to the statements of need for the national developments, Annex B. And it states that national developments are significant developments of national importance that will help to deliver the spatial strategy. And that's the point that comes in at the start of the document. And then just going further into the document at page 103, there is a page on National Development 3, Strategic Renewable Electricity Generation. And it says there that a large and rapid increase in electricity generation from renewable sources will be essential for Scotland to meet its net zero emissions target. And then further down under need, it says additional electricity generation from renewables and electricity transmission capacity of scale is fundamental to achieving a net zero economy. So what I would say in concluding on national developments is you can see how the national developments contribute to the spatial strategy, and there's the importance of contributing to the 2030 target from developments of scale. This is a national development, this application, and it is also, I think very importantly, one that can contribute to the 2030 target. So if consent was to be granted, it could be built and energised such that that electricity could come online to contribute to that target, not just for the electricity flow, but also, as we'll come on to see, the target in relation to the 20 gigawatts of onshore wind that the government wants to have in place by 2030. So sorry, that's been a bit long, but that's, I think, hopefully helpful in just giving you our position on what the national development means.
I'll come back to the targets later when we get to the onshore wind policy statement. So you're saying basically that that underpins the national development status underpins the spatial strategy in terms of this proposal because it's of a over 50 gigawatt capacity. Yeah.
Yes, 50 megawatt. 50 megawatt is the threshold in terms of the class of development defined at page 103 of NPF 4. Yeah. Okay.
And the timing of it in terms of obviously the construction programme and the development becoming operational, would that development, if approved, contribute to those targets within the 2030 timeframe?
Yes, the grid connection date is 2027. So if, let's say, consent was granted by ministers this year, then that gives at least 2 years for construction and discharge of conditions and then connection. So the timing is workable in terms of contributing to that target.
Okay, thank you. Nature Scott, do you have any? I think I would like to hear your views on what the implications are for national development status from your point of view.
Yes, well, in terms of implications, the reporter might find some assistance from page 97 of NPF 4, where we read that under the heading National Developments, on the left-hand side of the page there, we read that national development status does not grant planning permission for the development and all relevant consents are required. Their designation means that the principle of the development does not need to be agreed in later consenting processes, providing more certainty for communities, businesses and investors. So that's some discussion there about the implications of having a national development status. Ms. Harry, do you have anything you'd like to add from the Nature Scott side?
Probably only just reference back to page 4 of NPF 4, where it highlights that national developments should be exemplars of place principle and placemaking. So there's a link there to them being the right development.
I will come back to that point later on. Okay. So as a national development, it doesn't override the other requirements of NPF4. That's what you're saying to me. Yeah. Okay. Does anyone have any further points on that matter? No. Okay. So I'd set out in the agenda what I consider to be the key policies, which are policies 1, 3, 4, 5 and 11. Does everyone agree that those are the key policies? Is there anything else that you think I should be looking at?
I think these are the key ones. I would agree with that.
Yeah. You just got.
I've not identified any further ones, Ms. Harry.
No, we haven't.
Thank you. Okay, so just turning to policy 1 itself, which is tackling the climate and nature crisis. Just wondering, to what extent does NPF4 differ from the previous national policy position? In particular, can I have parties' views on the relative importance assigned to landscape between the previous planning position and the current position? So could I maybe start with Nature, Scott, on that one?
Yes, of course, ma'am. Ms. Harry, do you have anything to assist the report there?
Yeah, I mean, we do recognise that there has been a shift, obviously, with regards to landscape in NPF4. We'll talk about policy 4, I think, in more detail, and policy 11 in the individual policies, if that's more helpful to you. But with your question of the importance of landscape overall, there is a weakening in landscape protection. I think, you know, we recognise that. But nonetheless, the regional spatial priorities, and with regards to this development, if we look at page 22 of NPF4, the regional spatial priority here for Northwest Coast and Highlands does highlight the area has exceptional environment with coastal and islands landscapes, and they are an important part of our national identity. So there's a highlight here in the regional spatial priorities, and this is covered for all of the spatial priorities, but the majority of the shift, the major shift we see with regards to landscape protection will be in the wildland policy, which again, happy to go into more detail probably on that point later on if that's more helpful.
And do you see any weakening of the policy in relation to national scenic areas?
No, we don't.
Do you have anything else you want to add on that?
Well, I think we can take policy 4 now, if that's helpful.
I was going to move on to policy 4 separately. Suppose I was really at the moment just looking at the relative weights and the change in policy direction. So happy to park policy 4 for the moment, if that's okay. Yeah. Okay. Mr. Bell, same question. Do you see any shift in the national planning policy position from SPP NPF3 to NPF4 in terms of obviously the importance assigned to landscape?
Yes, I think I would generally agree with what Ms. Harry said. I think it was a very fair summary. We know from the explanatory report that went along with NPF4 that the government's justification for the change in wildland policy was to ensure targets could be met. That is clear. I don't think there's any disagreement on that. To answer your question about the relative importance of landscape and the weight to be given to that, and clearly if you're giving more weight to the benefits, that means less weight gives, in the balance, perhaps to other matters. Now, we get some helpful guidance in the onshore wind policy statement, section 3.6, which deals specifically with landscape and NPF4 and onshore wind. And if it's worth turning that up, that's page 19 of the statement. So section 3.6.1 refers to the climate targets, and it does say this means the right development in the right place. We'll maybe come back to what we take from that. But it says meeting the ambition of a minimum installed capacity of 20 gigawatts of onshore wind in Scotland by 2030 will require taller and more efficient turbines. This will change the landscape. Now, the original emphasis is underlined. This will change the landscape. So there is a clear signalling from government that there will be landscape change, and that should be anticipated. It goes on in the next paragraph to say that LDPs should seek to realise the area's full potential. So that will be for the Argyll and Bute LDP2 to deal with. But it goes on to say at the end of para 3.6.2 that the only areas where wind energy is not supported is national parks, NSAs. That's consistent with the previous position. But outside of these areas, the criteria for assessing proposals have been updated. And we'll see that in Policy 11. And it says, including a stronger weight being afforded to the contribution of the development to the climate emergency, as well as community benefits. So whatever weight was given before, i.e. up to the 13th of February, then it's stronger weight that has to be given now. It's a clear indication that stronger extra weight is being given to the contribution of a development. And that will link to what we say in policy, we look at in Policy 11, in terms of the impacts have to be addressed in the context of the contribution of a given development. So hopefully that's helpful in giving some specific guidance on NPF4 and landscape. It's the only guidance I can see that there is beyond what's in the policies themselves.
Mr. Hardy,
If I might just add too, Mum, yeah, it just add something there too. The next paragraph is worth reading. I know we'll probably come back to the OWPS, but 3.6.3 goes to this point about weighting. That the revised draft NPF recognises that significant landscape and visual impacts are to be expected for some forms of renewable energy, but makes clear that where impacts are localised and are appropriate design mitigation is being applied, they'll generally be considered to be acceptable. So clearly you got the evidence yesterday in relation to localisation. So that's a paragraph that's important too.
I'll come back to that specific point again later too, because I would like to raise it again today. I know we're not in the landscape session today, but I would keep that on the table for today too, please.
Thank you.
Okay, thank you. Let's see. So just looking still at Policy 1, is it possible, and this is probably just a question for the applicants and Mr. Bell, is it possible to quantify the contribution of this proposal to the UK targets, UK and Scottish carbon reduction targets? Just in terms of perhaps a percentage figure.
Yes, just bear with me. I'm just looking at the text on Policy 11, where in my hearing statement at paragraph 3.8.6, the headline points would be 72.6 megawatts of capacity. So nationally important contribution to installed capacity that could be operational by 2030. And the annual estimated carbon savings are approximately 116,417 metric tons of CO2. And to put that in context, I've set out that there are 42,000 households in Argyll and Bute. So the annual contribution would be our electricity generated that could power the equivalent of 88,000 homes on Argyll and Bute. So it would effectively provide double the required household energy consumption from electricity in Argyll and Bute. just to put this specific development's contribution into context. And I think if you look at a number of Scottish ministers' decisions, these are the key metrics that are often referred to in terms of the benefits that a development would give rise to.
So, obviously, developments vary in size, but in terms of how NPF4 should be interpreted, does it matter if the contribution to a proposal is smaller than another? Does that have any weight in the considerations?
I think in Policy 11, the requirement is in considering the impacts, significant weight will be placed on the contribution of the proposal. So if this was a 5 megawatt development that wasn't nationally important, I think I wouldn't want to belittle the contribution that scheme would make. It would still be a valuable one. But I think the guidance to decision makers is that you now need to look at the actual contribution that's made from a development. A previous position that was in Scottish planning policy 10 years ago was whatever the scale of development, it should be afforded significant weight. The approach seems to be different now. So I think it is appropriate to look at the strategic nature of the project and the benefits. And that also comes through when you look at the policies, because two of the policies certainly that we'll deal with have a development management test that takes into account benefits of national importance. And clearly, if it was a small scale development of under the town and country planning regime of 20 megawatts, it wouldn't necessarily deliver benefits of that nature.
And so would you consider that all schemes of a national level, national development level, should all be considered to have the same sort of weight just in terms of the contribution that they make? Or is there a difference between the scale of national developments and any kind of weighting? How would you interpret that?
I think where you have a development that is over 50 megawatts, then that will attract significant substantial weight. There are some schemes in Scotland that are very substantial, which are hundreds of megawatts, and that may well justify a position of super weight or very substantial weight being afforded to those benefits. So it'd be a matter of looking at the individual circumstances in a given case. But certainly in this case, I would say significant or substantial weight to those benefits, given the scale of development and the timescale in which that these benefits can be delivered.
Mr. Gregg, do you have any comments on that matter in terms of the sort of scale of a wind farm proposal and any weighting that you think I should give to the matter?
Nothing to add from my perspective, Ms. Harry?
No, nothing to add.
Okay. And this is again a question that's probably just best to the applicant. I'm just wondering, I haven't particularly seen it. Well, I've yet to highlight this matter, but is battery storage important in terms of the contribution to the targets, and if so, can that impact be quantified? Sorry, your mic's off, Mr. Bill.
Sorry, yes, I was just confirming the capacity is in the order of 5 megawatts of battery storage. And battery, as we know, is treated as generation, so that can be added into that benefit summary that I gave. It has the benefit of being able to clearly store energy and release it when it is most in need. And also, rather than being curtailed or the development, it can have that facility to absorb energy and then release it when it can be taken onto the grid. So we're starting to see more of that co-location take place and the capacities increase. So it is an added positive aspect of this project.
Okay. Does anyone have any further comments to make on policy one?
Nothing from me, ma'am. Ms. Harry, anything?
No.
Thank you. Okay, so moving on to policy 3, which is biodiversity. I'm not going to raise any of the issues regarding ornithology or anything in detail here, but I'm just looking for parties' views on the extent to which they think significant biodiversity enhancements would be provided in relation to this proposal. And to what extent, if there are benefits, to what extent would they be demonstratively better than the site as exists at present? So could I perhaps start again with the applicant on that one, and then I'll turn to Nature Scott.
Thank you. Yes, I think this is policy perhaps that needs more guidance, and we know from the Chief Planner letter that is to be forthcoming. So perhaps Nature Scott on the call can tell us a bit more about that when it's coming and what it will be broadly, because that I know the industry will very much welcome that. But in the absence of transitional guidance, this is a project where actually there are enhancement proposals, and I referenced the Appendix 7.5 of the FEI in terms of the Outland Habitat Management Plan, which has proposals for creation of preferred habitat for golden and white-tailed eagles, which will result in a net benefit. I think it's difficult to make precise judgments on whether that's a significant enhancement in the absence of guidance. So I think that's why the Chief Planner's letter is quite helpful, that I've referred to in my hearing statement. That's the letter of 8th of February, which again confirms that there's no accepted methodology yet. That's coming. And there will be some proposals that will not give rise to opportunities to contribute to enhancement. And it's for the decision maker to take into account the policies as a whole with material considerations in each case. So I think here there is a positive contribution that can be made to the nature crisis. It can be secured by way of a condition. It can attract weight. I think the bigger point as well is that there will be some major or national or EI developments that need to meet this policy. And I've got another case, which is an industrial warehouse. And it's very difficult for that particular project to satisfy that policy. But the other point to bear in mind is that by dealing with the climate crisis, the biodiversity crisis is also alleviated. And this is one of the projects that clearly has a fundamental role in dealing with the former that can also indirectly deal with the biodiversity crisis. But notwithstanding that, there is actually a positive offer that can be secured for the project. Thank you.
Could I turn to Nature Scott, please, for your view on that?
Yes, thank you, ma'am. This topic's obviously with the remit of Nature Scott's interest in this inquiry, but I wonder, Ms. Harry, is there anything that you can add to assist the reporter?
Only that it's early days and we're not at the stage yet of having that guidance. So I think for this proposal, we're not able to give a view as to whether it would meet this particular policy.
I suppose in the absence of the guidance, I need to make some form of a judgment on whether what is being proposed is mitigation or whether it steps into enhancement. So I just wondered if anyone has any sort of, in the absence of the guidance, perhaps maybe Nature Scott could, does your consultation response allow me to make that judgment?
Possibly not. I think that that would require some significant work, probably on our behalf, to do that in the absence of guidance. A little bit chicken and egg situation we're in here, isn't it? So I don't think it would.
Okay, that's fine. That's, you know, there's nothing wrong in saying that, but it's just the position that we're in at the moment. So, Mr. Bell, do you have anything further to add?
Sorry, I missed that last answer in terms, as Harry saying, it doesn't think it would.
The consultation response, the report is asking if the consultation response that we've provided would give her a steer on whether the biodiversity policy had been met. And my answer was that it wouldn't, because we haven't been able to undertake that.
Okay, thank you. Nothing further, ma'am. Thank you.
Thanks. Okay, so if no one has anything further on biodiversity, I'll move on to policy 4, which I think we'll probably, I'll start asking some questions, but I think we've probably got a lot more to say on this policy than just my questions. So the two questions that I have are, parties disagree on whether the objectives of designation and overall integrity of the NSA will be compromised. I just wondered if there's anything more to say on this in respect of the policy requirements. Let's start with Nature Scott, sorry.
Yes, Ms. Harry?
Yeah, we can provide a bit more clarity on that. So the last couple of days, you've heard evidence from both parties on the significance of effects. So the first part, I guess, is leading up to being able to apply this policy test and to whether either party considers significant effects on the qualities. Clearly, there's differing views, but there's at least a view from both of you to take forward. If it might help to go to CD 13.060, which is an internal note of Nature Scots.
Yeah, if you just give me a wee second, please.
Fine. And along with our landscape policy framework might be helpful as well, so I can give you another reference.
Sorry, what was that second one?
And the second reference would be CD 13.038, which is our landscape policy framework.
Okay.
I'll just wait for you to get those.
Okay.
And the first document, it's not page numbered, but para 10 might be useful. I mean, it's an internal note, this, but it essentially sets out our thinking and has something in front of you rather than just relying on me telling you.
Yeah, sure.
There's essentially how our process in Nature Scott is to look at those effects that have been identified by our landscape professionals, and then we start to have applied the test, which we know in this instance we have the same policy test broadly that we had, well, almost exactly word for word, that we had an SPP and actually an MPP 14 before that even. So it's been going some time and it's been tested quite considerably. And so we've used this and applied this wording and interpreted the wording of objectives. So for national scenic areas, the objectives are directly referenced to their special landscape qualities and the special landscape qualities as they've been described within the documents that you've seen in previous sessions. And that's what the landscape architects have been assessing against. So there's that direct comparison there that they are assessing against essentially the objectives of that particular designation. So our understanding, as it's set out here, is objective of the designation is the general safeguard, conservation, enhancement of interest for which the area has been designated. So as I say, for NSAs, that's the special landscape qualities.
Okay, and do you want to turn to the other document?
So this, in the second document which I raised, which is our landscape policy framework, again, there's highlighted here And it goes on to the next part of the policy test. So it's just a document for you to have to hand, because I suspect your next question might be about integrity. So it's just so that we have here the cross-reference where we, in paragraph, it's in the appendix A11 actually. And I'll just read that for you. For some valued landscapes, judgments on the acceptability of change are determined against policy tests. And again, as I say, it's referencing MPP 14, but that's fine because we've got the same one here. For proposals, including NSAs, Nature Scott, consider this broader approach is relevant when considering proposals in the regulatory system. So we still abide to that same approach that we've outlined here. And then the following paragraph in A12, SNH interprets the objectives of the designation as the safeguard, conservation and enhancement of the interest for which the area is designated. For NSAs, this is their special qualities and character. And I'll just leave it there so that we can talk about integrity a bit later.
Okay. Mr. Bell?
Yes, these are helpful references, and I think, as Miss Harry says, the landscape architects have been dealing with the specific matter of the special qualities, and you can see how that links to the objectives of designation. So that is helpful. In my hearing statement from paragraph 3.10.6, I've sought to draw out from Miss Oxley the key points of her evidence that relate to those matters. And then clearly there's a difference of position between the two landscape witnesses, and a view needs to be taken on that.
I don't know whether you're going to come on to integrity, but there's also the paragraphs in the notes, so in CD 13060, which talk about overall integrity. So that's the fourth bullet point down. So the wholeness of the area, the unity or soundness of the whole being unimpaired, but recognise that the entire area of the designation is valid, and so on. And there's reference there to Caplick. And then paragraph 11, so that deals in a bit more detail with the first limb, and then paragraph 12 with the second limb. So I think it's just worth reading all of those. In a sense, there's a planning judgment to be made about, and you can't get away from that, to what extent any individual SLQ goes towards overall integrity and the degree and extent of effect. I think that's agreed as a test. It doesn't help you because there isn't a sort of silver bullet. You have to take the evidence and decide on what is probably an agreed set of tests as to whether or not that test is passed, or not. But I think the language in or the explanation in paragraphs 11 and 12 need to be read as well.
Thank you. That's helpful. So just in terms of part C 1 and 2, I've obviously got a clear difference in opinion between the parties on part 1. So it's an either or set up. So what was parties' feelings then in terms of how I would interpret the balance between the two in terms of the adverse effects, if it's accepted that there are adverse effects on the integrity of the NSA? What's parties' views on how I should weigh up those against the importance of any social, economic, environmental benefits of national importance set out in part 2?
I think we've just got to be clear in looking at the test. So the first part, Roman 1, is objectives of the designation and the overall integrity of the areas will not be compromised. So that's one set of parameters. And then the second part, or any significant adverse effect on the qualities for which the area is being designated. So it seems to me that they're dealing with slightly different things. So I wasn't sure of your question. I mean, if you want the, you know the case really from the applicant that this doesn't come close to undermining the objectives or compromising the objectives of designation of the overall integrity of the area, and we say nor does it amount to any significant adverse effects in Limb 2. That's our case, but I don't think that was your question.
No, I'm playing the position of either myself or the Scottish ministers having to look at this situation where if it was accepted that Nature Scott's position is correct and that the objectives and overall integrity would be compromised and any significant adverse effects, how would we approach whether or not those adverse effects are outweighed by the benefits of the proposal?
Well, I think
it's a scenario. That's all it is. If that was the case, how would you make that decision, that weighting?
If I may, and then Mr. Bell may come in on this. So the first part, so Roman 1 doesn't include, because that's in my reading a bit more serious, if you like, because that's undermining the entire of the integrity. There is no balancing exercise in that Roman numeral. However, so you'd have a fail against that particular policy, but that doesn't stop in the overall planning balance, the benefits of the scheme outweighing that breach of policy for Roman 1. Within Roman within Roman 2, so C2, you have an internal balancing position whereby you can have significant adverse effects on the qualities for which they've been designated outweighed by benefits, which would mean that within the ambit, within the framework of policy that you then have a policy pass. So you can get to the grant of consent on both routes, absolutely, but Limb 1's more serious. And I think that there would be a fail. You'd then be outweighed at outside in the planning balance. Obviously, you've got to look at other policies. We'll come on to policy 11. But there's an internal weighing mechanism within Roman 2, which would allow you to pass policy 4 as well as get any sort of super added benefits from the national benefits in the overall planning balance. Mr. Bell, I don't know whether you want to add anything to that.
No, I think that's accurate. My position that I've set out based on Miss Oxley's evidence is, as Mr. Hardy put it, we're not close to failing that first limb. I think that would be an overstatement of the evidence as I put it. But in the event that position was not accepted, then in Limb 2, the benefits would need to be of national importance. It's been very difficult up until now for any individual electricity generating station to pass that test, but we have a changed position now with the national developments and national benefits that we talked about just earlier. And that's clearly part of the government's approach going forward, is to recognise the national importance of getting to those net zero targets, as we've just discussed. So in those circumstances, this would be a development that would qualify as one that would deliver the social, economic and environmental benefits of national importance.
Mr. Gregg, do you have anything further to add on that point in terms of how those policies should be interpreted?
For my part, I think Mr. Hardy's explanation was fair and helpful. I'm content with that summary. You obviously know the Nature Scott position and Dr. Wimble's evidence to the contrary, that the Narachan would indeed fail the policy test set out in Roman numeral 1, and it's for you, ma'am, to weigh up the competing evidence you have and make your own decision on that. In terms of the wider planning balance, I'm not sure Nature Scott can provide much assistance to you, unfortunately. That's for yourself. Nature Scott have their particular remit and interest, of course. Ms. Harry, is there anything you'd like to add?
Just that I think the first part of the policy test, as we set out quite clearly, in our hearing statement, and you know, that is where we are in disagreement with the overall effect of the developments, and that's in the previous sessions to deal with mainly. With regards to the second part of this policy test, I think, you know, we are in agreement that it's about the balance, but I guess we're balancing a nationally important landscape with a nationally important development here. So there has to be a consideration as to are the significant effects enough to be outweighed by the, you know, national important contribution of the development, and that's where we think that balance lies in the second part of this test.
Thanks, that's helpful, everyone.
Can I just be clear though, because there's, I think, a danger lurking there, that the LVIA, which looks at landscape character and visual effects, is that, you know, I think it's agreed by Dr. Wimble, that's a building block, and that gives you some of the technical underlying information. But then you go on to a separate test, which is whether or not any of the identified SLQs are compromised. So it doesn't follow. We're in Roman 2, any significant adverse effects on the qualities for which the area has been designated. The finding, our case is, there are, it's not the same thing to say because there are some moderate significant visual effects in the LVIA that automatically follows that they are significant adverse effects on the qualities for which the area has been designated in the Roman 2. That's a decision within the SLQ exercise. Mm-hmm. And as you know, we don't accept that. So the position from the applicant isn't that, you know, we absolutely know in Roman 1, but nor are we you know, almost getting into that. You don't get into that balancing exercise in Roman 2 because the significant effects that we've identified don't go to the SLQs, and that's the evidence which we're being led. So it felt as though in that discussion there was a sort of short-circuiting of that, and we're all just agreeing that we're in Roman 2, and that's not the case.
Mr. Gregg, would you agree with that?
I think the discussion for the last 2 days is really focused on compromising of the overall integrity, compromising of objectives of designation. But I take on board what Mr. Hardy's saying there.
So in terms of the first and second part of policy 4C, do you agree with that interpretation that Mr. Hardy's just offered?
I think we would, obviously the Nature Scott position here is that it would fail Roman numeral 1 and Roman numeral 2 is engaged in terms of the balance, which would be a matter for UMAN.
But on the first part of C2, would you agree that any significant adverse effects on the qualities is the special landscape qualities assessment that I have to look at to interpret that policy?
I think that would be a fair yes.
Okay.
Yeah, it's because I mean, just to make the point, it's because there is something different about national parks and national scenic areas, and those designated areas, they've all got reasons for designation. That's the very reason why Dr. Wimble was saying that the SLQ assessment is something different. So in my submission, Roman 2 is dealing with that additional element where you get which NSAs, that's the SLQ assessment. So our adverse effects don't engage the Roman 2. On our view, obviously there's a difference in the evidence between the sides, but our case is not that we are in a Roman numeral 2 situation either.
Okay. That's very helpful. I know that the evidence that Nature Scott gave in terms of their objection doesn't include wild land, but as discussed at the pre-inquiry meeting, I do have to understand the position and present an interpretation of the policies for the Minister in relation to wild land. So firstly, could I just seek parties' views on whether or not the effects of development out with wildland areas is still a consideration? it's not that it's, you know, the terms of policy 4 don't rule it out as a consideration that I must take account of. Could start perhaps with Nature Scotland.
Yes, Ms. Harris.
Yes, so we've obviously given this some considerable thought, not just with this proposal, but with others in the planning system. So it might be helpful just to explain that we do think there may be instances where Nature Scotland might think it's helpful for applicants to provide assessments for developments that are out with wildland areas to inform the best possible design of those proposals. That seems to make sense to us, good sense and good practice for landscape architects. You know, we have an assessment criteria to do that. Wouldn't necessarily be a requirement, but it would be something that we think would be helpful. So that may have been an instance had we had this policy in place for Narachan, for example. So we may have asked for that. And as it turns out, we do have a wildland assessment. With regards to your particular question on the very last sentence of that policy, our interpretation is pretty much exactly how it's written. It is, for a development such as Narachan, it is not a significant consideration for the decision maker. But we do think that there is something in informing the process of the good design development, essentially, in understanding sensitivity to the landscape.
So, taking the precise wording of the policy, it says it's not a significant consideration. Would it be reasonable to interpret that as that it's still a consideration?
I think
just
that would
perhaps
be
not a significant one. So in that case, should I take account of the wildland assessment that's been provided in this case?
I think it's useful information before you. You don't have, we haven't raised it as a substantial, it's not a reason for our objection, but it's useful information before you, I would say.
Turn to Mr. Bell. Would you agree that wildland is still a consideration in this case?
Yes, I think it's a minor consideration because I think the wording's informative and it's clear. It says it will not be a significant consideration. So it doesn't say it's not likely to be or should not be. It's very clear wording. It will not be. So whatever the circumstances of a location of a development out with a wildland area, if it's 100 metres or 10 kilometres, it's not a significant consideration. And the reasons for that are set out in the explanatory report to NPF 4, which says if this policy change has been made so that targets can be achieved. So it's very clear it relates to the generation of renewable energy. The government wants to see the 30 gigawatts in place, so the 20 gigawatts in place by 2030. And that must mean that there will be landscape change. And we went over that earlier. So I agree it's not an absolute no, it's not a consideration at all. So it's a minor consideration. And I recognise the point Ms. Harris says about good, design of development, and any responsible landscape architect would take account of sensitivities in the landscape. I think that is good practice. But for present purposes, it's a minor consideration, and given the distance and the very minimal effects, I see that as remaining as a very minor consideration, but that would attract very limited weight.
Thank you. And should I have some regard to the wildland assessment that has been undertaken in this case? Is this a matter that I should consider?
I was going to say, just from a legal perspective, I think it would be a dangerous course to ignore something which is before you. And the wording, I mean, after all, this, I know it's important policy, but this is just policy at the end of the day. And there's a duty to take into account, all material considerations. I think what it does do is mandate, and really in line with what Mr. Bell's had to say, it mandates the decision maker to give a certain amount of weight and importance. It's telling you that there's something has changed. It is not to be given a significant consideration, but there may be something. in that assessment, and maybe something that you do need to take into account. So yes, it's material. You're being told not to place much weight on it, but there may be something of interest.
Thanks, that's very helpful.
Yes, just in case it's of assistance, ma'am, I'd agree with that categorisation. You know, it's not a significant consideration. I'm not sure I'd categorise it as minor, just because that wording I don't believe appears in the policy. But yes, not a significant consideration, but some regard could be held to it.
I don't know whether we could agree. I mean, Mr. Gregg, I don't know. Insignificant. It's difficult, isn't it? I mean, it's material. And actually, the degree of significance may not be the same thing as weight that you attach to it either. So I think we're better off just sticking probably to the wording of the policy, which is not significant material weight that you think ought to be applied. We're saying very limited. That would be a matter for you. I probably, rather than try to put our own gloss on what the policy has said.
Sure, it's helpful just to explore these matters and get a bit of clarity in everyone's thinking.
It's not an outright ban, is it? And actually, had it tried to go there, there'd have been difficulties in telling you that you can't look at it. So, as with all things in planning, a bit of judgment, but the mandate really is telling you the sort of weight that you should attach.
Thanks, that's helpful. Does anyone have anything else that they wish me to consider in relation to Policy 4?
Just one brief point, and that's about the reference to local landscape areas in Policy 4. And I appreciate that's not an issue that the inquiry has looked at, but insofar as there are local landscape designations in Argyll and Bute, that's the areas of panoramic quality that you may see referenced within the LVIA. That is where there's a significant policy change brought in by NPF4 in paragraph D, where it follows a similar architecture in the wording to paragraph C that we've just been over. But it allows for any development that even that would have significant adverse effects on integrity of a local landscape or a nature conservation area to be outweighed by benefits of local importance. So that's not an issue, as I say, but it's just of note. I think that is a further change in landscape policy.
Okay, thanks. So I was just going to say I will look at the LDP policies later on, but it's just helpful to note that, yeah. Mr. Hardy.
Well, it's probably of academic interest. I don't want to spend too much time on this, but so C1 and 2. So objectives of designation and the overall integrity of the areas will not be compromised, or any significant adverse effects on the quality to which the area is being designated clearly outweigh. That's what we're dealing with. But then when you get to the to D, its development will not have a significant adverse effects on the integrity of the area or the qualities for which it's been identified. Fine. Then you get to Roman 2, any significant adverse effects on the integrity of the area are clearly outweighed. What D2 doesn't have is a test in relation to the qualities. You'll see that there's a difference there. So it just goes, so it's any significant adverse effects on the integrity. And I think that highlights, the reason I raise that is because in the case of NSAs, you do have special landscape qualities which underlie their designation. And I think that just goes back to the point I was making, that you are looking in Roman 2 of C Roman 2, adverse effects and qualities is a test applicable to the SLQs underlying an NSA. So I think that just helps contextually within the document to reinforce the point I'm making.
Thanks.
I just got one last point on Policy 4, which, if that's okay, just to raise that in A, we do have a statement here that says development proposals which by virtue of type, location or scale will have an unacceptable impact on the natural environment will not be supported. So there is reference here to location, which I think is useful when we're thinking about the citing of this proposal, and also a test with an acceptability. So I think, this may just sort of segue into policy 11, but we may want to look at policy 11 for where acceptability is referenced in the E2. So it's just to make that connection between this policy test, which that raises that, and then coming on to policy 11, which I suspect you may want to do.
Okay, so, Mr. Bell, would you agree that policy 4A is applicable also in this case then?
Yes, I mean, that is just a continuation of what we had in SPP, where there was a reference to a paragraph 203 of SPP that if there were unacceptable effects, that was a development should be refused, and that's just a general principle in the planning system that's obviously well known, but the same as SPP 203.
Ms. Harry, do you have anything else to add? Policy 4? No. Okay, Mr.
I
Gray.
think we'll get there, but then I think that's a very helpful link through to policy 11, because policy 11 E2, which will
Do you
go
want
on
to turn to policy 11 now, or I was going to quickly have a very quick look at policy 5 first?
No, it was just to agree really with Nature Scott that there is a link, because policy 11E gives you some indication of what might be deemed to be acceptable. So I'm just agreeing that there is a hook.
So that's the hook, right? Okay.
Yeah.
And nothing further from me, ma'am, on policy 4.
Thank you. Yeah, right, and this is just a quick question really, and just looking for some clarification in relation to policy 5, if you just give me a wee second. So policy 5 references the likely net effects of development on climate emissions and loss of carbon. So from my point of view, I've been looking at chapter 6 of the EIER in terms of effects on carbon, and appendix 6.2 is the carbon calculator. I'm not clear if that was updated to take account of the revised proposal, the carbon calculator. Mr. Hardy, could you possibly clarify that for me?
The answer is it may be one of the clients, and I've got clients in the room who are off screen. Either they can give me some instructions, or I can come back to you on that. It's a very detailed point.
It's just something that I haven't been able to identify, having looked through the documentation. So yeah, if it's possible to clarify that, we can come back to it later.
Park that if we're going to have a mid-morning break, then we can come back to
that would be lovely. Okay.
Yeah.
I think what we'll do is we'll now deal with policy 11, and after we've dealt with policy 11, we'll have a short break. Would that be okay here? Okay. So turning to policy 11, obviously I'm happy for us to run through the points as you see fit, but I just wanted to ask a couple of questions first, just from my own point of view. I was just wondering what parties' views are and how to consider whether, in the absence of any guidance, how to consider whether net economic impacts would be maximised. And Mr. Bell, you could probably best ask that one of yourself.
Okay, thank you. Yes, this is a new matter. I think what I take from that is really the government re-emphasising the benefits of the economic benefits and the social benefits that can come from energy development. And there is no guidance on what maximisation means, but certainly the conventional reporting has been done for this project in terms of construction and operational employment generation. But what the applicant is also committed to doing is actions that can ensure that there is maximum exposure to the local supply chain. So that would be things like, if consent is granted, then there's clearly certainty that the project is likely to go ahead. There can be breakfast meetings with Chamber of Commerce co-sponsored groups. So that's getting together all the suppliers within the area, and the applicant is already putting together a database of local suppliers, from haulage contractors to fencing contractors and so on. And that's sort of project level activity that can take place. I think what's important to recognise, I think the government's also getting at here, is the onshore wind sector deal, which is referenced in the onshore wind policy statement. And if we look at that, chapter 5 in the onshore wind policy statement, for example, section 5.2, supply chain, where it says, paragraph 5.2.3, we recognise that at present Scottish manufacturing supply chain for the wind industry is weak. Over the coming years, we have a real opportunity to create an established remanufacturing industry based on circular economy principles. And then at 5.2.4, it says Renewable UK is currently working to fully understand the supply chain opportunities for Scotland and the rest of the UK. We expect the report shortly, and we will use it to inform our approach to maximising supply chain benefits. And then later in the document, it refers to the sector deal. There will be collaboration amongst unions, workforces, suppliers, government, developers, and so on, in a similar way that that's been progressed for offshore wind in Scotland. So I suppose in some ways, like the biodiversity guidance, Renewable UK have still to report, and there's a bigger picture in terms of the remanufacturing. So several years ago, there used to be tower manufacturing on at Machrihanish, not far from the site, and that would have been ideal in terms of being able to maximise supply chain from that type of manufacturing facility. Unfortunately, that's gone, but I think the expectation is that given the scale of development that's envisaged, there may be a stimulus to those aspects of the supply chain to come back into the economy. So I think there's two aspects. One is the project-specific actions that really can't really be taken until the development has consent, because then there's more certainty. And then there's that wider piece that the government's setting out in the onshore wind statement that will be further developed over the next few years. So I think what you could take as decision maker is recognition of what the developer has done and is committed to in terms of those supply chain project actions. And then secondly, recognition of what the government's saying in the onshore wind policy statement that will be further developed with the sector deal specifically.
And that this, you're saying that this development would contribute towards those second wider aims of the I suppose it would help the government deliver those wider aims.
I think the way you could put it is that and I think I'd maybe touched on it in my evidence in the written statement, was there's going to be a range of projects coming forward in Scotland which collectively will give impetus and stimulus to the supply chain. So the more consents, the greater the demand, and then the greater, hopefully, supply of manufacturers that may go to towers, and certainly, for haulage contractors in Argyll and Bute that are based in, I know in Campbelltown, they are well placed to put in competitive bids. I would have thought for this project as well as other contractors.
Okay, thank you. Let's see. Yes. Just looking now at 11E, I'm wondering whether we're really seeking parties' views in turn. I know we discussed this matter yesterday, but I'm just looking at it in terms of an interpretation of Policy 11. How should I define localised effects And in this case, would it be reasonable to conclude that the effects are localised? So could I possibly turn to Mr. Bell first on that one and Mr. Hardy?
Probably if I sort of start, the answer is that yes, absolutely. That's the evidence that we've called, and that's the evidence that Nature Scott gave as well. You asked those questions, and I mean, it seems clear to us in relation to the geographical extent, which I think Dr. Wimble described as a few square kilometres. She's right, we agree with that. Yeah, absolutely. And I think given in the context of the general policy thrust, the wording in the NPF4, recognising that, and it's in policy 11E2, so significant landscape and visual impacts, recognising that such impacts are to be expected for some forms of renewable energy, and that's referenced in other parts of the obviously the policy statement as well, where you have just the sort of localised, geographically localised effects you've got here. That, I think, in contextual terms, makes the point. There are other schemes where you have much broader effects over much larger areas, and here, Nature's Scott, I don't think they disagree. What they're saying is really their case is the intent. I mean, we disagree with this, obviously, but the intensity of the effects, that's really what Nature Scott are saying, that they are the intensity of the effects on the SLQs are sufficient to undermine the integrity of the area as a whole. This is not a case where they're saying this is about, a massive geographical spread. So there is a question for you, obviously, to determine, but I don't see that question being one about whether or not the effects themselves are localised. I don't know, Mr. Gray, whether you feel that's fair. That's the evidence as I understand it.
I think, to be fair to Dr. Wimble's evidence, I think when he was referring to localised, he was meaning localised in the context of the NSA rather than perhaps localised in the context of, or as it's used in terms of policy 11E2. He's obviously not the policy witness. Ms. Harry, are you able to assist on the Nature Scott interpretation of localised here?
I think there's a couple of issues in here. One is, and without straying into Dr. Wimble's evidence, I think you're right. This, how it was explained, was our evidence is in light of the NSA, and policy 11 Part D directs us directly to back to policy 4. So of course we know policy 4 is engaged. So with regards to localised, I think the word magnitude might be helpful here. It's about the magnitude of effect on those qualities that's really at play here. And
a more eloquent way of putting what I was saying, sorry.
No, it's fine. It's purely because it's an LBA term, so it might be helpful just to link back.
Yeah, no, I agree. I was talking about intensity, but you're absolutely right. Yeah.
So if you've still got the document open that I referred to previously, which is the CD 13.060, it's the same paragraph that actually Mr. Hardy had taken us to earlier, which is paragraph 11.
Okay, I've got that.
Okay, just about the second sentence down from that, it's talking about I think we talked about the first limb of the test, which we've moved on from. But what might also be helpful is to talk a little bit here about the description. So I'm just going to read to you that any such compromise, neither is any such compromise dependent on an extensive area or large number of special landscape qualities being significantly affected. So just to be clear, and I think we're all in agreement here, it's not about how many qualities are corrected. In this case, it's 2, but it could easily be 1. It's not about how much of the area is affected. It's about how well expressed the qualities are in those areas affected and how the landscape is experienced. So once you're on your site visit, I think those are the sort of questions to have to mind when you've got the qualities in front of you. Is how well expressed in those areas that significant effects or effects are displayed, which is probably, both parties are agreed on the areas affected, I think, significant or not. And that's where the test lies. It's not about how much of that area.
think that's very helpful, and would agree. And what that does, again, is reinforce the I mean, I don't think this is, nobody's disagreeing about it, but it reinforces that the SLQ assessment is something different in relation to NSAs, and that's very much your policy 4 test. And so the SLQ, the question that you're asking about SLQs isn't, for all the reasons that have been explored over the last couple of days, just a function of distance or whatever. You get to, there are a number of other factors. But in relation to the point that's being made in policy 11E2, that is about localization of factors. So in terms of your LVIA assessment, and the evidence in this case is that it's agreed that there are localized effects. So I'm not taking away from anything that's been said. I think we're actually agreeing, Ms. Harry. Mm-hmm. This is about SLQs. The SLQ test is policy 4.
Yes, and actually there's either not engaged or less weight to this particular policy test in 11E2 because we're already directed to policy 4 earlier on. So I think this is about landscape and visual effects.
I agree.
It's obviously this policy session is a bit wider than just the NSA. Obviously, this is for me to try and get parties' views, which are maybe not very fair in nature, Scott, in relation to the LVIA assessment that doesn't affect the NSA. But
that's right, ma'am. I think the Nature Scott's evidence has understandably been very focused on the NSA. So
yeah, so it's just
context in which all our evidence should be viewed, really.
Sure. So if it's not appropriate for me to be sort of trying to get your view on how to define localised effects, that's fair enough. Suppose from my point of view, I've got to look at the LVIA as well as the assessment of the special land quality. So in terms of the LVIA, both parties were agreed that effects were localised.
Yes.
So in using policy 11 to interpret the effects, you're both content that's localised. So irrespective of the geographical areas referred to within the LVIA, some of them sound as though they're a bit larger than localised. Is where in general terms would you consider an effect to be localised and where would it not be localised? I'm just trying to explore that particular point.
I think it's very difficult in any given case to be nice to have a neat kilometre range. I don't think you can do that. But when you've got the ZTVs, you've got the LVIA material, our view is that not leaving aside the SLQs, is that the effects are localised, and that is both in solus and cumulative landscape and visual.
So even the aviation lighting effects, which are from the others that talking about, obviously I've got to consider what the interpretation of the policy would mean for Argyll and Bute as well as the NSA. So
yes.
Lighting will be seen to some degree back and forward between Argyll and the proposal, but also in certain locations, looking at the ZTV, a wider area around about that does affect parts of Argyll. Just for instance, the island of Gia. So I need to just be clear in my mind that while the effects are that the parties have agreed that the significant effects are localised, I'm wondering how I should interpret the kind of the geographic areas referred to in the LVIA.
I think there's a number of points there, if I may. First of all, of course, ZTVs, whether they be landscape ZTVs or aviation lighting ZTVs, theoretical. That's the first point. Yeah. So we've got to be very careful there. Secondly, significance is a very different thing to discernment and being able to see. So as we've set out, yes, you may be able to see things or observe, of course, but that doesn't pass a threshold of significance. And when you look at E2, significant landscape and visual impacts is what it's concerned with. So
That's
it's
what I
not,
just wanted to check with you. Is the second sentence a continuation of the first one? So the first E2 talks about significant landscape and visual effects, recognising that such effects are to be expected. So it says where impacts are localised. Does that only mean significant? Is that your reading of it, that it's only where significant impacts are localised?
I think it must be, because what it's saying is, in trying to make the change to facilitate development, that there's a recognition that all large scale, particularly, I mean, well, let's deal with it's wind. It deals with all renewables, but wind principally, you are going to get significant landscape and visual effects with any modern wind farm. That's just a given. So that's what the policy is trying to do. And I think that it's saying there, you're going to get those. And then the second sentence, it would have been helpful had it inserted the word where such significant impacts. It doesn't do that. But in my view, the sort of sensible reading of that is that it refers to significant. And I think the reason you can take that with some assurance is if they were non-significant impacts, then they wouldn't have been picked up by the EI and the planning system, and the environmental protection system wouldn't really be bothered with them. So it would be odd, wouldn't it, to talk about significant impacts being inevitable and then say, don't worry about that, we'll just deal with the non-significant ones, and if they're localised, you're all right. It doesn't make any sense to me. So I think it should have had the word significant inserted in it.
Mm-hmm. Yep.
If I could come in briefly, ma'am, just to clarify the Nature Scott position, because I think that there might have been an element of confusion in the discussion there. So I was trying to say earlier that, to be fair to the evidence of Dr. Wimble, his evidence has, of course, been focused on the impacts in the NSA, and I understood his evidence to be, in response to your question about localised effects, to be in that context, so localised in the context of the NSA as a whole. But what Dr. Wimble and Nature Scott haven't done here, given their objection focuses on the NSA, they haven't provided any evidence about whether these effects are localised or not in terms of the wider LVIA, which is obviously about more than just the North Ireland NSA. So I don't think we can really provide much assistance in terms of policy 11E2 and whether the impacts are indeed localised or not. That's not been the focus of the Nature Scott's evidence to this case, understandably.
Yeah.
So I just want to make that clear. The Nature Scott case has obviously been focused on policy 4, as we're directed to do so by policy 11, given that the interest here is about the impacts on the North Ireland NSA.
Okay, and in terms of the North Ireland NSA, just to take you back to your word earlier, you were just saying that you didn't entirely agree that effects of the NSA were completely localised. I'll need to go back to your precise words, and there was a slight disagreement in your interpretation.
Well, I think localised isn't really a concept that we find in policy 4 when we're looking at the NSA, but it's a concept in policy 11E2 more generally, more widely, when you're looking at the development. And what I'm saying is that we haven't. You asked Dr. Wimble about this, of course, in your own questions at the session, at the inquiry session, and I think perhaps there was some speaking at cross purposes that you were perhaps asking. I'm not sure if this was the case, ma'am, but perhaps you were asking with 11E2 in mind, and Dr. Wimble was responding in the context of his evidence on the NSA. So there's a difference there if you're following me in terms of their different assessments. Really, I think
that's been useful to explore, just to see that there is a slight difference in approach between the two policies as they apply to the NSA. I think we're all agreeing on that point. Yeah. Yep. Okay. Just in terms of, again, interpreting policy 11, I just wanted to turn to the mitigation, which is still under E2. So Is mitigation a consideration in terms of the effects on the NSA? Does this part of the policy apply in terms of the NSA?
I think overall that policy, that maybe if I put it this way, that policy applies to the overall development. Firstly, in terms of how it has been composed, and in my hearing statement 3.8.19, I sought to bring out some of the key points, having discussed with the landscape architect about how mitigation has been applied in terms of specific design mitigation. So the big point, the starting point, is about the reduction in size of the development from 17 to 11 turbines in response to consultee comment. And the second point is about the landscape architects, and this came through in Ms. Oxley's evidence about designing a coherent cluster there, ensuring that this scheme fitted in successfully with the other developments in views from the surrounding landscape, which does include Arran, Gia, and the other coastline areas. So I would say yes, it's an overall design approach in terms of that design mitigation, exactly what is referred to within Policy 11, Part E2.
So if I'm considering the effects of the NSA, this is still applicable, that there has been mitigation, that the mitigation applied. I should still take that into consideration in relation to my assessment of the effects of the NSA here. Yep,
yes,
you would agree that?
Yes.
Yeah. Yes. Mr. Gregg, Ms. Harry, would you agree that that part of the policy is applicable?
Well, I would say, ma'am, this is a similar point really to the localised one, in that obviously when you're considering the development as a whole, Policy 11 is of course relevant, and you should consider all it says there. But when you are, as a decision maker, focusing on the impacts on the national scenic area, Policy 11D is directing you to assess those effects in accordance with Policy 4. So
is that additional, or is that?
Pardon?
In addition to Policy 11, or should it only be considered in relation to Policy 4?
Well, the wording at 11D is development proposals that impact on international or national designations will be assessed in relation to Policy 4.
So that Policy 4 only?
I would say it's probably, well, Ms. Harry might be better placed to answer, actually.
It is a directive policy, so I would suggest that possibly yes, that 4 is the important policy here, because I mean that's the directive of it. But if we can just pick up your mitigation point, which I think is the point that you started with, whilst mitigation isn't set out specifically in Policy 4, it is of course part of the EIA, LVIA process. So it will have been considered in coming to a view on, you know, when we're going back to the Policy 4C2 tests, in considering the significance of effect on those special landscape qualities. That significance is a result of residual effect. They are residual effects which will have considered embedded mitigation. So I think you're getting to the same point. It's whilst it's not using the word mitigation in anywhere in Policy 4, as far as I can tell, it has been considered, or should be considered, I should say.
I think if I may, perhaps try and bring all those points together. It seems to me that the tests that you are applying in Policy 4 will be the net result of the scheme and any mitigation that has been either embedded or technical in terms of design or in terms of technical mitigation. So in this case, things like the aviation lighting mitigation. So you look at all of that and then you decide on whether or not the tests in Policy 4 are satisfied or not. But this scheme obviously has impacts on landscape and other matters outside of the NSA, And so to that extent, policy 11 absolutely does apply. And you look at all those other things in relation to those interests. So whilst it doesn't specifically refer to mitigation, I think that's absolutely written into, or policy 4 isn't terribly interested in how you get there. What it's interested in is the net result. Does the scheme, as mitigated, impact on the or undermine integrity or on the special qualities? And then in general terms, you then apply policy 11. So I don't think it is an either or for the entirety of the scheme. I think it's policy 4 for SLQs and policy 11 for everything else.
Yeah. Okay.
Yes, I'd accept that summary. I think that's a helpful explanation.
That is very helpful. Thanks very much, Mr. Hardy. Okay. Yeah, I just had 2 more questions in relation to NPF 4. But does anyone have any other points they wish to make in relation to policy 11?
Nothing from myself. Miss Harry, anything?
No, nothing from me.
Mr. Bell?
No, nothing.
I think there's the cross references to the policy statement. I know we're coming on to that, but when we've had these hearing sessions before, I think it's important to read the documents together, given that the policy statement is specifically designed to describe the changes that have been made. So I don't think we need to go there just yet. We'll get there, but I want to flag up interpretationally that the policy, the OWPS helps.
Yeah, okay. Just in general terms, I had a couple of questions. So again, if Nature Scott don't have any comments on this one, that's fine. But I just wanted to consider how the various requirements of NPF 4 should be balanced when it's read as a whole. Mr. Bell.
Thank you. The Chief Planner letter is somewhat helpful. That's the one of 8th of February, where it refers to applying NPF 4. And it reminds us that the application of planning judgment to the circumstances of an individual situation remains essential to all decision making. And it says it's important to bear in mind NPF 4 must be read and applied as a whole. So that links back to what we just discussed in terms of policy 4 and 11. And the intent of each of the 33 policies can be used as a guide to decision making. Conflicts between policies are to be expected. I think that's helpful, and it's always been recognised that in a planning determination, the decision maker will be faced with some policies that pull in different directions. And it says factors for and against development will be weighed up in the balance of planning judgment. So I would say, and that's the approach I've taken, has been to understand what are the effects, what is, put simply, that degree of harm, and where does that sit relative to the position that this is a national development, and in policy 11 to look at the specific contribution. So looking at the key policies which we've, I think, agreed are engaged here, are they satisfied? And then in policy 11, that gives an overall in the round position on all the relevant technical and environmental topics in paragraph E. And then there is a conventional striking of the planning balance. But the big difference to, if you were doing that in January, the matter of weight was at your discretion. Now we're directed that the decision maker in policy 1 will give significant weight to the climate and biodiversity crisis, and in policy 11, significant weight to that contribution. So there's 2 areas where significant weight has to be applied against what is that identifiable level of harm. And when I struck it, I was of the view, well, in this case, Argyll and Bute Council, very experienced at dealing with wind farms. We have no objection. We've got no objection from any other consultee. There is one in this case, and fairly we've been over the evidence. My view was that that level of harm did not outweigh the benefits in this case. So that's how I approached NPF 4, and I think that is in line with what the Chief Planner is saying in the latest guidance. Thank you.
Thanks very much. Mr. Hardy, do you have anything to add to that point?
No, I'm happy with that. Thank you.
Okay, Mr. Gregg, do you want to make any comment on how the NPF4 should be applied as a whole in this case?
I don't have anything to add. We would leave the matters of the planning balance to yourself, ma'am. Ms. Harry, do you have anything to add yourself?
No, nothing to add.
Okay, right, thanks. I think this is probably an appropriate point for a short break. So let's see. If we reconvene at 25 past, would that be okay? Yeah. Okay. Yeah, that's about a 20-minute break. Okay, thanks.
Yeah, thank you very much. Bye-bye.
Thank you.
Thank you.
Hi. Hello.
Hi, David. I think we're
Hi.
on a break until 25 past.
Yes, we are. Just that I was on my phone and then I've come back in on my Surface Pro. So as long as that's it, I'm good. Thanks.
Can hear you fine.
Right. Yeah, I'm happy to start again if everyone's ready, yeah. Okay, so the next thing I wanted to look at in terms of the policy position was the local development plan policies in terms of their consistency with NPF4. And again, I suspect that it might put Nature Scot in a slightly difficult position, but if you do have any comments on these matters, I'm happy to take your contributions. So the core document reference for the current local development plan is CD 010001 and the proposed plan is CD 010005. And I was really initially just seeking parties' views on the extent to which the most relevant LDP policies, which I suspect are policy LDP 6 in relation to renewables and LDP 3 in relation to protection of the environment, what extent are they in alignment with NPF 4? And in particular, I suspect, is there any conflict in relation to reference to a spatial framework? So could I start with Mr. Bell on that one?
Thank you. Yes. I think the starting point for me would be what the Act says, and I put that down in paragraph 3.2.5 in my hearing statement in terms of the changes that have been made to the Town and Country Planning Act 1997 in terms of any incompatibility. So it doesn't use the word inconsistency, it's any incompatibility. And we do get a bit of further guidance, though, from the Chief Planner letter as well, which says that provisions that are contradictory or in conflict would be likely to be considered incompatible. So from my review of the LDP, I would agree policy LDP 6 is the lead policy, and it talks about there not being unacceptable significant effects, so that's fine. I don't see that as being contradictory or in conflict. But what it doesn't do is give direction as to the matter of weight to be applied. So I think it's not a major conflict, but it's a difference, I think, between the LDP policy and NPF4 policy 11. Where I think it gets more contradictory or probably in conflict is the supplementary guidance on renewable energy, which is based on SPP and the spatial framework approach. And I don't think any of that can be salvaged into today's decision making. So my view would be that there's not any significant conflict between the provisions of the LDP, apart from the matter of weight, and also the LDP doesn't reference net zero. And we know that net zero, we started the discussion this morning, is a key aspect of NPF4. But the supplementary guidance is more problematic insofar as it contains a spatial framework, which isn't within NPF4.
Yeah. Okay, so should I give any weight at all to the supplementary guidance, or do you consider that that is so reliant on the spatial framework that I need not now consider that as compliant here?
I would be hesitant perhaps to say no weight. I would take the view perhaps limited weight, where it has topic references that are still relevant, but any aspects of significant protection driven by the spatial framework approach would go and should not be given any weight. But the point I make in my hearing statement is that the topics that are contained within the supplementary guidance are already encompassed by the remit of Policy 11, NPF4 Policy 11. So that justifies Policy 11 being the lead policy overall for the development plan viewed in the round in terms of the two development plan documents being the LDP and NPF4.
Just in a second, I can say yes, absolutely, Mr. Bell. I'm hesitant about saying you don't, exclude anything. I think that, there are dangers in doing that. You look at it, but taking everything on board that Mr. Bell has said, you apply what weight you think you should apply. There will be variability in those parts, and we think very little weight. But I'm always hesitant to exclude things which may be material.
Nature Scott, do you have any comments on that?
No comments from me, ma'am. Nature Scots are obviously more focused on the national policies as a national body. I'd agree there's some useful guidance to be gleaned from the chief planner's letter, but I don't have any comments to make on the local planning policy. Ms. Harry, do you have anything to add?
No, nothing to add.
Okay, thank you very much. And the emerging local plan, which is under examination at the moment, and I know that there's been a number of sort of exchanges of correspondence and further information requests on that plan, so I'm not 100% sure what the precise stage it's at, although I know that it's not yet reached the reporting stage. But I just wondered if, Mr. Bell, if you have any comments on the weight that should be afforded to the emerging local development plan in its current state.
Yep, I'm involved in that process at the moment, so I've got some information. Certainly, the current draft plan dates from 2019, and it's been largely through the examination process, but the appointed reporter is currently issuing information requests from interested parties on the question of the consistency of policies with NPF4 and whether there are any incompatibilities that could be addressed at this stage. So the first point to make, though, would be that the lead policy in the LDP is subject to outstanding objections. Secondly, the reporter is at this moment issuing requests for information. They're due in next week, so it will be several weeks until I imagine there is a report of examination. So I think it's safe to put limited weight on aspects of the emerging LDP at this time.
And if the report is issued prior to me being able to report on this case to the ministers, would the weight that I give it increase?
Yes, I would always take the view that the closer a plan gets to adoption, if there's a report of examination that's got policy changes that are to be taken into account by the planning authority in publishing that final plan, then that would attract more weight.
So I should have some regard to the reporter's examination report if it's issued prior to this decision. Or is that, do you consider that not to be a relevant matter in this case? The council's not here to answer the questions, you see, so I wasn't sure whether or not they considered that they should make any further submissions on this case, or whether it's relevant for me to request an update from the council on its position. Putting that question to you, would you think it's reasonable at this stage for the council to submit a formal update to ourselves?
Having seen the content of the draft plan at the moment and being involved in how it potentially may change, obviously we don't know what the final position will be, but I haven't seen any evidence or suggested policy change that would lead to a substantively different policy framework than we are dealing with today. So from that perspective, I don't think it's going to be, put simply, make a difference to what we have discussed today. But there's maybe a separate legal point that Mr. Hardy may wish to comment on in terms of if that is a material matter coming into play to be considered before a final planning determination is made.
I think you get the flavour of what I'm saying. These matters should just be all considerations that go into the decision, and it seems to me we need to come on to talk about closing submissions and timescales and so on. But I can't believe that it would take the council very long at all to. I mean, you're really asking, I think, for a short update, aren't you, Mum? I mean, it's nothing. You're nothing.
Yeah, the problem is, even though I am a reporter within the DPA, I'm not party to the correspondence that is ongoing between the council and the reporter on the examinations. So I don't know what the timeframes are, and I don't know whether it's reasonable, whether my timeframe for issuing this decision is likely to be before or after the LDP2 is adopted.
Well, I mean, it may be that a kind of one-pager or a two-pager, just giving a factual update on where they are. That might be maybe enough.
So if the new plan is adopted prior to me finalising my report, then I'm faced with the potential of having to seek further comments from the parties and ask whether or not there's any further submissions to be made. It's an unusual one in that the council haven't objected in this case, so I don't anticipate the council's position to change.
No,
but
absolutely.
It's the I'm really just seeking your view on how you think I should consider the new LDP, if it's not adopted as currently proposed, if it changes the position in terms of renewables, would there be anything I would need to be taken into account?
Well, I think that you have to. Obviously, this is a Section 36 case, so that's the first thing to say.
Yeah.
But the development plan is material. Clearly, you need to have the most up-to-date position. I think all you can do is get on and decide on what you've got. But if there was a change, I do consider that to be potentially material in legal terms. And even if that didn't result in a change in position on the part of the council, and we certainly wouldn't expect it to, I think to have a letter or representation from them on record saying that, and then the opportunity for us to say, we agree with that position, is probably the watertight way to go.
Yeah.
Mr. Bell, do you agree?
Yes, I do. I think because there'll be the unusual situation that, in line with the amendment to Section 24 of the 97 Act, that will become the document that prevails if it is adopted.
Yes.
So you will have generally an SPP prepared LDP, albeit there's a late action going on to retrofit in NPF4 compliant policies, but that would be the document that prevails over NPF4.
Okay. I suspect that my position would normally be that if there is a change in circumstances, I would expect parties to bring it to my attention. And in that case, I would invite comments from yourselves as the applicant. I don't see that it probably has any consequence for Nature Scott.
I don't think it's really a Nature Scott issue,
LDP,
is it? Yeah.
So, and I think given your awareness of the situation, you could probably turn that around quite quickly, and it wouldn't delay my writing of my report in this case. So I think my answer would be, if you are aware, it should really be for the council to tell me, but if the council don't tell me,
yeah, then we can.
And I'm not aware from internal discussions, if the applicant in this case could undertake to let me know if there is a change in circumstances with the LDP2.
We can do that.
And in that case, I will invite a quick round of submissions.
It doesn't, I mean, it's slightly out of order. And I have absolutely no idea what your diary looks like, but have you got any rough indication of how long it would take you to write up the report, just to give us a flavour of how likely that situation is going to be?
I was going to talk about that at the end of tomorrow, but
I didn't want to.
My aim is to try and get this out as quickly as possible. So I've already made some start on filling in the basic gaps. So, the kind of bones of the report, with the intention of completing it early summer at the latest.
Right. So I'm not holding you to it, but sort of May, June time, something like that. So,
well, I suspect that I'm not able to get out on site at the moment until I'm really waiting on the kind of ferry situation changing a little bit. Yeah. So,
or you can swim.
So as soon as I'm still waiting on a confirmation from CalMac as to whether I can even get a booking across. So. Right. Once I suspect that my site visits will probably be completed in the next kind of month. That would be my aim, and then aim to have the report written by early summer.
Right. Well, if that's right, I mean, I'm not, as I said, absolutely not holding you to. If you just say June, then the likelihood helps us with the a likelihood of the council making that progress. That's helpful. Okay. I'm not sure we can take it much further, because there matters out of both our hands and indeed Nature Scott's hands.
Mm-hmm. Okay, so that's really all I've got to say in the local development plan, unless anyone else has got anything to add. So turning next to item 4 on the agenda, which is the onshore wind policy statement, which is core document 009010. And I've made some kind of notes of what I think are kind of key paragraphs for my own purposes, and I'll ask some questions in relation to those. But again, I would ask parties if there's anything they wish to particularly draw my attention to in response to, or to expand on matters within their hearing statements, or in respond to other parties' hearing statements. I'd be grateful if you could make those contributions. So my first question relates to paragraph 3.61, and it's talking about the climate targets and the ambition. That I'm focusing on a bit about the ambition for the minimum installed capacity, and the requirement to ensure that the right development happens in the right place. I'm just interested in whether parties think there is a tension between the aims of delivering the transition to net zero and enhancement of the natural heritage. So will I start with Mr. Bell on that?
Thank you. I think firstly, in terms of the targets, we have discussed this morning the 20 gigawatts target for onshore wind. So there's never been a technology specific target in Scotland, but the government set that as a minimum by 2030. And there's clear emphasis on the 2030 timescale, and I've referred to that a number of times. This project could contribute to that. And the other important target is the carbon emissions reduction, and I set that out on page 14 of my hearing statement in terms of the latest position to get to net zero. And although there was a successful meeting of the target for 2020, the Minister has made it clear that that was primarily due to the effects of lockdown and the reduction in transport in particular, and that there's expected to be a rebound. So I think I would say for your write-up, reference to that target's important, and also the onshore wind contribution. And to put that into sort of scale, I set out that 20 gigawatts is essentially delivering 130% of all the current installed capacity within less than 8 years. And it's taken us since 2003-4 to get to where we are today. So it is, as I put it, a mountain to climb. And I don't think that's an underestimate of it. So the targets are important, and I think that's why we see them specifically referred to now in Policy 11. In terms of your question about attention of getting to net zero and the natural heritage, I think what the government has done, in my view, is to give us a set of development management policies, and that provides where there needs to be a substantive focus in the term the right development in the right place, because in itself, I don't find that a very helpful term. And I've put it before, in a way, it's like a summary of the planning balance that needs to be struck in any given case. So I would say we need to look at the policies. We know that for sustainable place, there are a relatively small number of policies, and we've focused on those today. And that is what the government's saying to decision makers, to focus on the most relevant policies, read NPF4 as a whole, and strike the balance. And we get that additional guidance from section 3.6 of the onshore statement, as Mr. Hardy was referring to earlier, in terms of the changes that will occur to the landscape that's being signalled, and the stronger weight being afforded to the benefits. And that means something extra than was given before NPF4 came into force. So hopefully that's helpful, and that's what I would take from these documents in terms of resolving that tension, if there is one, between protection of the environment and getting on with delivering net zero. And I suppose that term, getting on, is important because you see in the statement of need for national development the urgency. The term urgency is there, and that term is also used in the onshore wind statement. And to finish up, I would say in the onshore wind statement, it uses the term in the last chapter that onshore wind is mission critical to the delivery of targets. And I think that is just very explicit recognition of the role of this technology. And that's page 49 of the onshore wind policy statement in the first paragraph. Thank you.
I'm actually going to come on to that one, but before I do, could I ask Nature Scott
if I could just might add something before
Nature
Scott come in. I think I agree with everything that Mr. Bell has said, but what I don't want the applicant to be caricatured as saying is that, well, look, that means, wind turbines everywhere and all of that. There is absolutely a balance written into this document, and it's clear from the ministerial forward, and it's page 4, and that's the 4th paragraph down. Whilst imperative to meet our net zero target, it's also vital that this ambition is delivered in a way that's fully aligned with and continues to enhance our rich natural heritage and native flora and fauna, and supports our actions to address the nature crisis and the climate crisis. So the way that balance has been struck with NPF4, which clearly is written to dovetail with this, is through the mechanisms of policies 4 and 11. So we are not, in this case, not having to rely on some sort of diffuse carte blanche or anything of that sort. What we are, we are within policy 4. We say it's just not engaged because the effects don't get there. And then you get into policy 11 with the additional weight that's attached to benefits and so on. So it's just recognition this is all very much facilitative of renewables, but a balance to be struck. But that balance is struck through policies 4 and 11 with which we say we comply.
I'm interested in Rachel Scott's take on that in terms of the tension between the two aims.
Yes, well, for my part, I'd agree with Mr. Hardy that yes, that the balance has been struck in policy 4 and 11. That's where we're directed to look. Ms. Hardy, do you have anything to add?
No, there's nothing to add because the statements I was going to go to have already been raised. So it's helpful.
Okay, thanks very much. In terms of the specific reference to this will change the landscape, just interested in what parties take from that. Does it apply to all landscapes? Does it mean that all landscapes will be subject to change, or will there still be some that have, because of the policies that we've just referred to, won't change as a result of the aims to meet net zero, etc.?
Could change. I think the answer is that absolutely all landscape could change, and I think that you could never say never. I mean, this is just policy as well, and it goes back to my point. Planning is all about, isn't it, balance. There isn't a single right, silver bullet for any form of development. So wind farm, and I'm absolutely, this is not the case, but wind farms within national parks and national scenic areas are not supported. That doesn't mean to say that you couldn't potentially have some overwhelming case where somebody said that it was. So potentially could change, albeit they are not likely to change because that's clearly what the policy is saying. But outside of those protected areas, that yes, there's got to be an expectation of more change because that is what is required in order to strike the balance. And the balance, if you like, at that macro level has been, let's concentrate on certain areas, and we'll say that they are to be not, wind energy is not to be supported there, but elsewhere you've got to expect a bit more traffic. So I hope that's it. In all areas there's the potential, but the carve out is that you are much less likely to get that in those nationally designated areas.
I would just add as well that term is straight after the reference to the target and the reference to taller turbines. So the government is saying, look, we want this target to be achieved. That's more than doubling what is spinning in terms of turbines at the moment in Scotland, and they will be taller. So inevitably, that's going to mean quite significant change over parts of Scotland where they are eventually deemed acceptable. And that is, as I put it earlier, I think just signalling to the decision maker that that is an expectation.
Mr. Gregg and Ms. Hardy, do you have anything to say on that point?
Just to say that, yes, this will change the landscape, and it's NPF4 that will, by and large, regulate how that landscape will change and which areas are most likely to change. And there's obviously strong protection in NPF4 for nationally designated areas, including the NSA, both for development within and development out with, as we've obviously been discussing during this inquiry. Ms. Harry, anything to add to that?
Yeah, just that Nature Scott has always been supportive of landscape change. It's something that's our foundation. We don't see these landscapes, Scotland's landscapes, as being preserved. Any of the landscapes, including national scenic areas, and the approach to assessing national scenic areas, just taking a slight step back, is setting policy aside. It doesn't really matter where the development is. It's more about effects on a particular quality that's important to us. And whilst policy takes a harder line or aligned approach, You know, we look at landscapes as a whole, we look at the effects on them. And I might just take you back actually to our policy statement, which is probably still on your tabs. So that's CD 13.038 again, if that's handy.
Yep.
Because there's a useful statement in paragraph 16. And I'll just read that out. Change is intrinsic to the landscape, with the appearance of many of today's landscapes significantly altered by relatively recent modifications. Scotland's landscapes will continue to evolve, in part through natural processes, but largely through human interaction in response to the need of a changing society. This will happen both in planned and unplanned way. SNH's approach is to influence, guide and manage this change and its forces, not to fossilise today's landscapes through frustrating its evolution. So I think that's just a kind of nice summary that is very much our view now, that we're, you know, here to help and guide change, and recognise that the reference in the onshore wind policy statement, I would agree with, you know, what's been said previously. It's very much reflecting the need for us all to recognise this evolution of development, but referencing back to right development, right place, its siting is still important.
Thanks, that's very useful. And just in terms of the reference about the installed capacity by 2030, should that affect, how should that affect individual planning decisions? Mr. Bill, Mr. Hardy.
I think there are several references to 2030 in the onshore wind statement, and there are some specific references in NPF4, and I think that was the starting point I took today, was page 6 of NPF4, where it says we must make significant progress towards this by 2030. So I would say it's developments that can make a contribution in the near term, like this project that has got a secured grid connection date, that is deserving of weight because it meets the Scottish Government's urgent policy objective, and that's set out in the two targets, the 20 gigawatts and also the target in terms of the emissions reduction under the 2019 Act that we touched on earlier.
Hardy,
well, I think that's right. In the conclusion, it's page 49. Deployment of onshore wind, mission critical. That's reference that David's already said. Mission critical for meeting climate targets and as an affordable, reliable source of electricity generation. So it's perhaps a common sense point, but it's not just deployment of theoretical wind farms for their sake. It's about generation of electricity. So in terms of meeting that objective, if there are schemes which have grid connections and which can be constructed, and there's evidence that you've got, you know, an experienced builder, developer that can deliver and start producing electricity, I do think that's something that you can take note of and give weight to in the balance. You know, what we're not saying, and I have been, you do read these things, you know, sometimes say, well, schemes, oh yeah, but we can't get grid connection for, you know, X number of years, and that's fine. There is still support for deployment, but this is about generation, and if you have a scheme that can generate, that counts.
Okay. Is the approval of the grid connection somewhere within the submissions as a point I can refer to? Is that, I can't recall seeing that within Mr. Hardy's, Mr. Bale's hearing statement. Was it?
Right, I can add that to the shopping list. We'll come back to, because there's some. We've got the point
for your closing submissions.
Well, I wasn't going to say that. No, I think actually that's information that you ought to have. But there's a few tidying up matters which perhaps we'll get to the end of this session, and then we'll come to how we might present that.
Yeah. Okay. Mr. Gregg, do you want to make any comment on that in terms of how the these ambitions might influence individual decisions?
Nothing to add from my perspective. Ms. Harry, anything to add?
No, nothing to add.
And this question is probably for both parties. So I'm really referring to paragraphs 3.65 of the policy statement, which is about landscape sensitivity studies. There's been strategic appraisals of the relative sensitivity of landscape to development types or land use changes. And quote, they're a tool to help guide development to less sensitive locations. These studies can inform a proposal's landscape and visual impact assessment. So I'm just interested in parties' take on that and whether or not that suggests that some landscapes are not suitable for such development and how those considerations have been applied in this case.
I don't think that with respect that I don't think it's getting at that. I mean, obviously there are landscapes that are going to be more or less sensitive in different ways. What I took from that was Nature Scott's guidance in relation to the transition from capacity studies to sensitivity studies, and we've explored that a number of times in other inquiries. So that move towards relative ability or carrying capacity for turbines. Of course, in this case, it is billed as a capacity study, but when you look at the terms of that capacity study, there is an assessment of sensitivity, which still is valid and would presumably be carried through to any revision to that. So there's a little bit of caution in relation to where that study deals with capacity. But as you know, that document is authored by Carol Anderson, and you've got the response, and there's no objection, and there's no breach of that capacity study. So I think that's what I took from that. And also just to say, of course, they are just a tool like anything else. They are a starting point. They are part of the library of materials that you've got. You have to go on to consider site specifics through the LVIA process, and in this case, obviously, through an SLQ assessment. Okay.
So that capacity study that we discussed yesterday does include a statement of sensitivity, you said here?
It's based on, I mean, I think the bit that, I mean, Nature Scott, correct me, but the guidance was just cautioning against studies which sort of purported to set out a threshold and say, you shouldn't build any more turbines. Yeah. After all, these are just targets, they are minimum. And what's really important to the decision maker is to understand how sensitive or susceptible the environment is to turbines. So this study absolutely does have that assessment. It would only be those parts of it which then strayed into, and you should not build any more turbines, that might be, would be more liable to be revisited following Nature Scott's guidance. That's I hope that's a fair summary. Mr. Gregg and Ms. Harry.
And we the parties did agree yesterday that there was no conflict with the capacity study.
Because Ms. Carol Anderson, who wrote that study, has said there is no breach of that policy.
Okay. Mr.
Sorry, ma'am. Yes, I just wonder, Ms. Harry, if you have any comments to make on Mr. Hardy's explanation there, or anything further to add?
Yeah, I would agree. That's a good explanation. I mean, there will be instances where some capacity studies will do exactly that. They will describe capacity, and they I think this is what it's getting at in the onshore wind policy statement, is to look at those again and with the light of the new guidance. But the what we have in this instance, whilst it's badged as a capacity study, is fallen under the term fit for purpose, and I think that the information's in there before you. So that's just to be clear that there is some capacity studies out there that they do differ in their style.
Yeah. Okay. Thanks. It's useful to have the parties' interpretation of the various parts of the policy document. We've probably answered this one to an extent, but I just wondered how just as a sort of a position, how far do parties think that this particular proposal is fully aligned with and continues to protect our natural heritage? Start with Mr. Hardy. You.
And the answer is yes, absolutely, we do. In line with the policies and the hierarchy that we've discussed. So, policy 4, obviously, you have to look at. We say we passed that. Assessed against policy 11, absolutely. We comply with the most up-to-date statements, and we gain the benefit of the significant weight to be attached to, to the benefits. So we say that in the way the balance has been struck, and I think that's the important point that we discussed earlier, the balance has already been struck. It's not we're told what the balance is, and that's through I think that it was a very good phrase from Mr. Gregg, which was regulating the change. So I think that's right. MPF 4 regulates the change, and we say that we comply with that.
And the Nature's Got view, obviously, ma'am,
is going to be that you don't. Yeah,
yeah.
I'd be very surprised, Mr. Gregg, if after 3 days you've gone. I agree with Mr. Hardy on that as well.
Yeah, it would be unusual.
Okay. So that kind of closes off the questions that I have in relation to the policy statement, unless you've anything else to add, Ms. Harry? No. Okay, does anyone have any sort of kind of further thoughts on the statement that we've not already addressed?
The only thing I'd say is that we, of course, this project has been in evolution for a long period of time, and it isn't the case that somehow we say we've got lucky because there's been a shift towards what's come out in and been adopted in February. It wasn't on that sort of, well, let's hit and hope something better comes along. This was always, we say, aligned with SBP and local policies, and that's the way it's been designed. I think what's happened, the change that's come, has clarified that management or regulation of change that we've discussed already, and there is an additional benefit that we gain. So I wouldn't want it to be thought that somehow this had started as a kind of, below the waterline, and then suddenly we've managed to get a lifeboat. It isn't that at all. This has always been policy compliant, but we're actually, as it's happened, we then get a boost because of the need to get on, which is articulated in the policy statement and NPF 4.
Okay, thank you. Other points on the policy statement? Okay. So I just wanted to talk very briefly about the planning balance. So there's references obviously to the right development and the right place, and I'm just wondering really whether or not parties want to have an opportunity to explain their position on the relative weights that ought to be given to NPF 4 and the policy statement as considerations in this matter, and in particular to the relevant provisions of the Electricity Act and Schedule 9 of the Act. I think we've discussed the sort of the weight and the balance within the NPF 4, but it's just that overall in terms of the planning balance, if you like, at the end of the day, and how that might fit against the requirements of the Electricity Act, or the provisions, because they're not requirements.
Absolutely. Do you want to start, David, and then I'll.
Okay, thanks. If Mr. Hardy comes in on Schedule 9 point, in terms, I think I've probably covered that just earlier in terms of the planning balance, where NPF 4 is a significant material consideration in this case, in this Electricity Act case, and there's a need to interpret and apply the specific policies which we've been through, and recognising that this is a national development that's important for the delivery of the spatial strategy. So I think we have that focus of in the policy framework we know the relevant policies, and we know the specific points at which significant weight comes in terms of policy 1 and policy 11. And we've properly been through the applicable technical and environmental topics in policy 11 with that addition of policy 4 and the specific development management tests there. I think the point I would emphasise, as Mr. Hardy touched on it earlier, is the read across to the onshore wind statement issued at the same time broadly, which has a specific section on NPF4 which tells us about the change to be expected and the stronger weight. So I would say for both of these documents, as important material considerations, substantial weight should be afforded to them in this Electricity Act case.
Mr. Hard, did you want to add anything to that?
Yes. So in relation to Schedule 9, of course, that's the governing act, and we'll set this out in legal submissions, that in formulating any proposal, the licence holder has or shall have regard to the desirability of, and that's then preserving, the list, natural beauty, flora, fauna, geological, physiological features, and protecting sites, buildings and objects of architectural, historical, archaeological interest, and should do what he reasonably can to mitigate any effects which the proposals would have. So in terms of primary legislation, this is in a different position, obviously, to a TCPA scheme. And, shall have regard to means that there's got to be a consistency of effort that's shown through the development of the application and through the EIA process that special regard has been had to those things. And you might think in this case, well, that's one element of that might be the reduction from the 17 turbines down to the 11. You listen to consultation responses and take all of those on board, and the responsible developer does that. And in my view, there's nothing raised by any party to say that this developer has not had special regard to the desirability of all of those things. Now, there is a disagreement, of course, in HSCOT about where we end up, but in terms of the statutory provisions, if you're satisfied on those, that is the statutory test that needs to be complied with. What is material below that in the consenting process, of course, is everything, and that is the development plan, that's SPP, that's OWPS, and all those SLQSS, all of those other things. But what I just want to do, there's a danger, I think, in these cases of not being clear about the legislative backdrop to Section 36 and Section 25, and there is, because this is the chosen mechanism from the government for delivering national scale electricity generation projects. And if the test was, you shall, or the test was set out in the Electricity Act, that would be a different thing. They are primary tests, but actually the qualifying criteria which should lend support to this are set out in Schedule 9. In terms of relative weight to this thing, it's obviously a matter for you, but I think the obvious point is that you've just got, and unusually, helpfully, you've just got the most recent articulation of the way the government wants to manage that change in NPF4 and the onshore wind policy statement. There aren't many decisions, I have to say, where you've got a month-old framework of policy to help, and that is an important thing. That's sometimes true. These get stale and you might be 5 or 6 years on and people go, oh, this is outdated, but here you have got a bang up to date set of policies which tell you how to approach it.
Yeah. Okay, so Scott, do you have any particular feelings on the, how I should consider this in relation to the requirement, not the requirements, I keep saying the considerations of Schedule 9 of the Act?
Yes, I largely agree with what Mr. Hardy said there. You should, of course, have regard to the matters that are set out in Schedule 9 of the Act, and material considerations and relative weight is, of course, a matter for you, but I'd also concur that if it was me, I would be affording significant weight to NPF4 as recently adopted statement of national government policy, which now forms part of the development plan. But it's, of course, a matter for you, ma'am.
And would Nature Scott consider that the regard has been had to Schedule 9?
Sorry?
Sorry, I don't think I can answer that for you.
Okay.
I think the Nature Scott focus has, of course, been on the national policy here.
Okay. Okay, does anyone have any other points they wish to bring to my attention on policy matters?
No, thank you.
No, nothing from the parties. Okay. So this is this final session that Nature Scott will be participating in formally. So what I'll do is I'll address some of the matters that I would normally address at the sort of final hearing tomorrow, where the council will be present. So we had discussed yesterday closing submissions would be 31st of March for Nature Scott. You happy with that?
Content with that, ma'am. Thank you.
Yeah. Okay, I now this morning have got a copy of the case summary, which I've not managed to read yet, but what I will be doing is be reading that after this session today, and I will be able to provide a comment on that tomorrow. So what I will do is probably the applicant will get my clarification tomorrow at the hearing session, and the council will, but as Nature Scott are not going to be present, I think what I'll probably need to do is get the case officer to send you an email just to clarify what our requirements would be.
If it helps, ma'am, I may be listening in covertly to tomorrow's
right, okay,
session.
that might be a bit.
You can't resist, Mr. Gray.
I can. I'd like to see it through every day.
Okay. Well, that saves me another bit of work tomorrow afternoon then. Okay, so I don't think there's anything else to pick up on today.
Well, a number of things, if I can.
Yes, certainly.
So come back on a list of things. So carbon calculator tool.
Sorry.
Had a look.
Yeah.
No, it's all right. Had a look at this very quickly. I'm not sure that it's been updated, and it does seem to us that does need to be, or it will be helpful for it to be done. I wonder. I've asked, well, how long it'll take, and we're told about within 10 days it can be done, but whether or not just to get around the FEI position, you would request that was required for the purposes of the inquiry. I can't think anybody's going to be interested particularly in it, but if you're able to do that, we can submit that.
Yeah, I'll do that this afternoon.
So that's the carbon calculator. The other thing is, and this may involve Nature Scott, so I just want to raise it now, that's involving the additional. There were a number of points on the lighting that we discussed yesterday that we were going to try and help with in the lighting hearing. Right. And so some of that was technical material. You recall there was some stuff on comparables and certainty over what you were going to be looking at, and there was a point about the visualizations and making sure you got the right resolution, those sorts of things. So what I thought the best thing to do was, we can deal with that orally in the hearing, but I thought the best thing to do is put that in writing. So we put together a note. I've not looked at it, but it's done. And I would like, obviously, Nature Scott to see that, and what I was proposing, and obviously the council need to see that. So what I was going to propose was that we circulate that as soon as we can this afternoon. We can send it direct to the parties, directly to you. I suspect, what time is it now? 12:15, by 2:00 or something like that. I absolutely want Nature Scott to have the opportunity to say something if they want to. Maybe if they're not going to appear formally, that could be done in writing. I don't know. It may be that there's nothing in there. We're certainly not trying to. This isn't a hijack or anything like that. It's just trying to help with some of the factual information and the things that have come up. So we might want to build in, or we could revisit this tomorrow, you know, Nature Scott putting in a written response or something. I don't even know how long the note is, but I told them 2 or 3 pages. I don't know. But it's confined to those things that were raised by way of clarification. That is all it is.
Okay. Trying to think what would be the best means to deal with that.
Well, I wasn't anticipating a note really. What was?
Yeah.
What
I was anticipating was some further advice in terms of my site visit locations. That's what I thought I was going to get, which I didn't think. I was just expecting it, and that would be a very informal exchange of comments, which we could do in around, say, within 7 days. Informally, it didn't need to be part of the kind of, if you like, request for information. But I suppose we don't know what's in the notes. So
but also it isn't as easy as that. You know, unfortunately, because one of the questions which went on from that were, are they being operated at that limit? What's the flex? You know, when I asked the question to try and provide that clarification, it wasn't a simple yes and no, you can go and stand here and look at that because it's more complicated than that, as I understand it. Sure. So right. I've not seen
site visit, is that right?
Sorry, Karen.
Sorry, it relates to the site visit though, the note. It's to do with the technical specifications of the lights that are to be viewed.
As I understand it, it deals with a number of points. But so another one of those was this point about trying to find a way of getting the higher resolution images, because we had that discussion about condensing images into JPEG images through the DPA website, and it was about what. And I think you asked the question. You were seeking some clarification on that, Mum, about whether or not. Well, would that make any? I think the question you put was, would that make any difference? So if you were condensing the files, would you end up with the same sort of issue that was just smaller or bigger? That was a question I think you put to.
It was more of a comparison between the two viewpoints. Would, you know, in condensing the documents, would both come out the same, or could
the answer is no. Exactly. That's one of the issues that I think that, as I say, I haven't seen it, but that was dealt with as well. So we will be dealing with that tomorrow in the hearing, because I don't see how we are going to go back, aren't we, to localized effects. So it was just to try and help rather than put that informally orally tomorrow. We've just tried to collect those things together in a note, and that's all. So it's trying to be helpful. But what I was proposing to do was to circulate it, and if people wanted to comment on it, absolutely right.
I think the best way to handle it, because I've not seen what it is, it's quite tricky not knowing whether to treat it as a late submission.
Nor have I. I mean, we had a discussion about what was going to go in it, but I it was designed to help and is just in response to the questions that were raised. That's all.
I think the best thing to do, if you submit it to the case officer, copy it to Mr. Gregg.
Yep. And the council.
And the council. And if parties want to treat it as a late submission, if they could let me know. If they wish the opportunity to comment on it, could they let me know?
Yeah.
And tomorrow's session is only in respect of aviation lighting in relation to Argyll and Bute.
Yeah.
So I don't think it's a matter that would require Nature Scott to participate actively tomorrow. So in that case, I could take a view.
It does go to the question, of course, you asked a question about whether or not you can condition. Do you remember that? There was a point about whether or not you can, because there was the discussion yesterday and the day before about
the technical specification.
Exactly, that was the crystal rig condition. So I don't know.
Sorry, I was going to say Nature Scott had reserved the right to participate in the conditions hearing. So if you wish to participate in that tomorrow, I'm open to that.
I think
absolutely.
Well, that's very kind of you both. I think the Nature Scott were quite content with where matters got to with the conditions after their input, so they weren't intending to participate in the conditions session, and we haven't lined anyone up to do so, and it'd be quite last minute, I think, to get
Well,
someone from Nature's got to attend that.
What about this? We will have a discussion on the matter at the conditions session. And if there is any change to the proposed conditions or any discussion on changing the conditions, we could offer Nature Scott the opportunity to comment on any revisions to the conditions.
That would be appreciated.
As a written submission, yeah.
Yes.
Yeah. And would, again, obviously the council, if they're faced with something new tomorrow and the way the conditions normally it would be, we could do a fresh round of comments if need be.
Yeah, I think that's very helpful, and we're just trying to bring some strands together. But so I think the outcome from that is I'll have a look at the note. Obviously, I will manage and control what I think is appropriate, circulate that. People have the right to respond, and then ultimately, if there's anything that or people don't feel as though they can do that in time, then I would absolutely be supportive of a short period just to come back. But it's not very long. I'm actually told it is 3 or 4 sides. I think that's what I'm told.
Just in terms of timing, I know normally we try to give 14 days if possible, just because it's kind of gives folk a bit of breathing space. But I think on something like this, would parties be happy? Obviously, I don't have the council here, but a 7-day period would be really helpful for myself. Just in terms of getting any comments, just in case I do get an opening in the weather and.
Well, should we, if we said sort of 7 days provisionally, but then if there's any more time, we can liberty to apply.
Okay.
Yes, I'm conscious that I just don't know what's going to be in this note, and if it requires me to speak to Dr. Wimble again, then I'm not sure what his availability is like, given that he's gone off into the sunset. But
into the dusk.
Into the dusk, indeed.
Okay.
But let's do 7 days provisionally, and Mr. Hardy, obviously, I'd greatly appreciate it if the note could be kept very tight.
Absolutely, yeah. Absolutely, yeah.
Okay, so what we'll do is we'll circulate that this afternoon, and if you could make your comments back to me as soon as possible, Mr. Gregg, just in terms of whether you're happy to treat it as a late submission to the inquiry process. And whether you think you wish to make any comments on it, and we'll initially set that at provisionally 7 days, and then we'll, if you think you need more, you could let me know.
Sounds sensible, ma'am. Thank you.
The final thing on the shopping list was about grid connection. You raised a point about whether or not that was in the it was achievable. I think 1.4.2 of Mr. Bell's hearing statement, but I think if you're wanting more than that, I'll have a call with my client just afterwards and see just what we can do subject to a commercial redaction. But I do think that it ought to be in.
Okay.
We're making something of it, so I think you need to have some evidence.
Yeah. Okay. Is there anything
That's it.
else?
Those are my list. Those are my 3 things. Yeah.
Okay. Well, could I just thank Nature Scott very much for their assistance and participation, and thank Mr. Bell and Mr. Hardy. I'll reconvene with yourself tomorrow at 9:45 with the council. Slight change in time tomorrow.
Thank you very much.
Okay. Thanks very much, all.
Bye-bye.
And
Bye.
see you then.
Thank you.
Bye.